Looks like it's time, everybody. Let's get started. As you'll recall, we're going to pick back up our hearing on House Bill 2416. Then we've got a few more bills to work. So, yesterday we had Natalie give us an overview of the bill. We had a chance to ask her questions, and we'll continue to have that time. I don't want to rush that, but any questions for Natalie at this point? Anything you thought about overnight that you'd like to get clarified?
Mr. Chairman, I'm trying to find my electronic hand.
Just use your voice, Representative Carmichael. It works just fine. I hear you. What's up?
You are so kind, Mr. Chairman. As you might recall, I asked that legislative research do some work for us, and they have done so. And I know they provided that work to the chair. It's entirely up to your discretion, as far as I'm concerned, whether that's distributed the rest of the committee and made a miscellaneous document so that it's a public document, or whether you and I keep it to ourselves. But to go a little bit farther, the information that I was looking for regarding delegation of legislative authority was not so much the curb case that research found for us, but I was really looking for better information on to what extent the legislature can delegate its collective authority to, for example, the Legislative Coordinating Council, or for that matter, any other special committee that we might come up with, such as a KEMA-related committee. And I don't know whether there is any authority on that topic. I know there's an LCC rule, and we have a statute about the LCC, but I don't know whether there are any constitutional implications, or to what extent we can pass a statute that says, when we're not here, we're going to let a group of legislators act on our behalf. And so if there is authority or guidance in that area, it might be helpful in looking at the options to have that from research. And I'd ask the chairman consider obtaining that for us. Thank you.
Very good. So first of all, your email, you should have all just gotten that email. I had Kathy forward it out to you. So you've got that to read and consider. And we'll have research and or reviser continue to look in the issue that Representative Carmichael just raised.
Thank you, Mr. Chairman.
Representative Samsel.
Thank you, Mr. Chair. Just a big picture question. Reading through this bill, it looks like the intent may be that these, once we get these done, these would be permanent changes to KEMA. Is the intent kind of moving forward, if you're able to share, that we would probably, this will be the bill, if you will, for KEMA before we adjourn in May? Does that make sense?
This is likely the bill before the end of March, so not May. I mean, we've got that March 31st deadline. That the disaster expires. Many of the things that were in 2016 and then Senate Bill 14 from earlier this year sunset, and so we have some issues to address between now and then. So I don't know if that answers your question, but
it does help, yes, Mr. Chairman. And the reason I ask is, speaking with some other representatives on this committee and even senators, believe it or not, over on the other side of the chamber, there's some big picture concerns that I think many of us share that frankly aren't really, this legislation continues to move in a positive direction, but I think it's still missing some very big pieces. So if this were to be the final piece, if you will, before we leave in May, I don't know, I guess I'll raise those at the appropriate time, but that's helpful information. Thank you.
And I should add, I wouldn't say this is the only piece, because there are certainly things that were in Senate Bill 14 or Senate Bill 2016 and Senate Bill 14 that also sunset that are not being addressed here because they're not, in my opinion, not really KEMA specific. So look at, telehealth or the immunity pieces or curbside liquor. I mean, there were a number of things we packaged together, and it was my desire that other committees deal with those, the appropriate committees. Some of that's been done and some of it has not been done. And so we may need to try to pass something else before March 31st. And you'll also notice that in the House bill, we do not have a provision to extend the disaster. So the disaster expires on March 31st, and then unless the legislature takes some sort of action. So that would require a different piece of legislation or a resolution. So there are multiple pieces moving forward. This isn't necessarily the only one.
I hear you, Mr. Chairman, and I appreciate that information and understand that. I think my concern would be, though, that this is the heart, actually, of where the concentration of power under KEMA is going to be, and it perhaps get into the previous representative's concerns a little bit, but in a different fashion. But it's the accumulation of power, whether it's in the governor or a handful of representatives or senators, versus ways to spread that power among the legislative body as a whole. But this isn't the appropriate time for it, but that's helpful information.
Got it. Okay. Any other questions for Natalie? Or me, I guess. Seeing none at this time, we will move on to proponents. And I don't see Eric, but I see Ryan. So Ryan, you've got it. Ryan Krieghauser's here on behalf of the chamber.
Now they can hear me in virtual world, I think. Thank you for having me, Mr. Chair and committee. I appreciate the opportunity to talk to you about this very important legislation, and I've submitted written testimony along with Eric Stafford from the chamber. I'm appearing here as legal counsel to the chamber, given that I've had a lot of litigatory experience with KEMA and local governments in the context of KEMA. And so I just want to limit my comments, if I could, and leave myself open to questions. But really, our comments to this legislation are similar to what we testified in the Senate about. And I'd really like to focus on three areas. First, it's very important, the 72-hour hearing part of this legislation that you have, whereby citizens can come and seek a hearing in front of a court and get that hearing within 72 hours. That's very important. The two pieces to that I didn't see in this legislation that I might suggest to the committee is one, in the experience with local health orders under 65-129, that series of statutes, particularly 65-129C, there is a notice requirement that a local health officer put in their order that citizens, you actually have a right to a hearing within 72 hours. And actually, at the beginning of the pandemic, there were a number of local jurisdictions that left that out of their local health orders, and that was brought up to them very quickly by myself and others. And so I'd bring up to the committee that perhaps putting a notice provision in any of the applicable orders, that there is this remedy available to citizens, because otherwise they may not know that they could go to court and seek relief. The other thing I would add is that in my experience with isolation and quarantine hearings, families, small businesses, and people who are subject to these orders were very hesitant to go file an action. And under 65-129C, I might add, you actually can have a counsel appointed for you. According to that statute, you can have a doctor appointed for you in an isolation quarantine hearing. And even with those protections, families and small businesses and individuals were uncomfortable going to a court. And really, the statute contemplates this situation by which someone just shows up at the courthouse, somehow files a petition for an isolation and quarantine hearing, gets that served on the county somehow, goes through all the procedural mechanisms where the county says, oh, you need to serve the local health officer personally, or serve the treasurer or the county clerk, and go through all that, and then get into court, and then the court will appoint them an attorney. And that's just not practical. That's not the way it works in practice. People don't just show up to the courthouse and write out a petition for an isolation and quarantine hearing. And so one suggestion I might make is that perhaps an aggrieved party that prevails is able to get an attorney's fees, but there has to be some access to counsel to have a 72-hour hearing that is effective. And then I also suggested that there are some other statutes that may be incorporated into the provisions that a 72-hour hearing would apply to, in particular 65-202. That's a very key statute in the infectious disease statutes that a lot of local health officers used for all these kind of bizarre orders that don't really nicely fit into 65-119, which is limiting public gatherings, or 65-129, which is the isolation and quarantine series of statutes. So when, like a mask order, for example, is issued, or curtailment of business operation hours, or limitations on capacity, or limitations on certain team sports that can happen in the county, all of those are issued under a different authority, and the local health officers, by and large, cited 65202, which contains language that says all known measures can be used to stop the spread of an infectious disease. And really, that's quite broad. And I might note that the criminal enforcement provision does not include 65202, which is interesting. So those strange orders, we have argued, don't have any criminal enforcement authority because it's not included in the Chapter 65 criminal enforcement statute. But perhaps 65202, 65119, and 65101 should also be subject to a 72-hour hearing possibility if someone is aggrieved under those orders. And so those were the main comments I had about the 72-hour hearing, but I will say that this is a very important due process right that I was glad to see made it into this legislation, but those are the suggestions we might have on that. The second thing I wanted to talk about is this concept of what I've called illegal rulemaking that we saw through the pandemic. So what we saw in many cases, especially during the reopening process, was the governor would issue an order and it would include vague and ambiguous language. And the example I mostly talk about is a restaurant versus bar. There was a time during the reopening process where a restaurant could be open, but a bar could not. But those terms were not defined in the governor's order. And so it came down to local authorities to decide the difference between a restaurant and bar. And we defended a bar in Emporia that was prosecuted criminally for opening up during that time. And that watering hole, if you will, said, hey, we qualify as a restaurant, we sell food, we have a food service license, and we focused on selling food, we are a restaurant, we qualify as a restaurant. And the problem there was that an employee of the local health office, actually it was a Flint Hills Community Health Center, I believe, said, well, my definition of a restaurant is that you have to have 30% of your sales derived from food. And that wasn't written down anywhere. She just decided that. And that, in many contexts in state government, constitutes rulemaking. And sometimes the legislature will give over to agencies the ability to fill in the gaps and give definitions with the force of law, but that's subject to the Kansas Rules and Regs Filing Act. There's notice, there's a comment period, you can have hearings on it, and then you actually promulgate those rules in written form. So everyone knows what the rules are. Here, under the reopening process, in that situation in Emporia, there was no notice or comment time. There was no hearing. There wasn't even a written down rule as to what constitutes a bar versus a restaurant. And when you give local folks that kind of authority without any kind of due process, I mean, an example in that situation would be, what if a local health officer was just a teetotaler and they felt alcohol was evil and they just decided, if you sell any alcohol, you're a bar. It's up to them to make the definition. So they got prohibition in their county just like that, you know? And so that's one thing that I would suggest, is that you make it clear that, particularly in long-term disaster situations, that some kind of rule and reg authority needs to be clear that it exists. And actually, the Adjutant General has rule and reg authority, and for whatever reason, they chose not to promulgate any regs during this situation, but they already currently under KEMA have the ability to issue regulations. And so that was another topic that I thought I would bring to the committee's attention. And then you're back and forth with a minority member, as well as Representative Samsel clarified some things as far as where this legislation might fit in globally, and that may leave some of the concerns about 48933. But that is a piece of KEMA that I'd say really needs to be addressed, because under 48933, we currently have litigation on file in Sedgwick County on behalf of a gym that basically says they're entitled to compensation because the government used their property. And 48933 says if their property is commandeered or otherwise used, and we don't really know what that means, it's not really defined in KEMA. And so our argument has been, under current law, you owe compensation because a shutdown is using their business. And the Attorney General has asked, and we agreed, that we stay the case and bring this to the legislature for a more global solution. And we have done that. We submitted a bill on Tuesday to come with a compensation proposal to solve this globally. And that's the retroactive piece, what happened during the last year. But going forward, I think it's important that counties, cities, and businesses all know what the rules of the game are. Counties should know if they are basically ringing up a bill by keeping businesses shut down under curfew orders. They should know that. Everyone should know that, and they should be able to judge and balance whether or not that's necessary. They should be able to look at the disaster situation and decide, are the actions we're taking beneficial enough to us to pay for it and be able to balance that? And so that's another piece I wanted to bring up to the committee. Other than that, it seems like a lot of the differences between the House and Senate versions really are policy making, legislative oversight, legislative delegation issues, and they both have kind of a civil rights review piece with the Attorney General. And, all of that is very beneficial, and we are glad to see the legislation moving in that direction. But I'm happy to stand for questions.
Thank you. First up is Representative Samsel.
Thank you, Mr. Chair. Thank you, Ryan. In reviewing and preparing for today's hearing today, I've read your testimony, very helpful. I appreciate it. I also read George Washington's farewell address from 1796, believe it or not. I found a lot of it very helpful and on point for what we're getting into here. My question is hopefully very simple. All other things being equal, who would the Kansas Chamber rather have making decisions to govern Kansas moving forward? Would it be the Legislative Coordinating Council in conjunction with the governor, or would it be the other alternative, the legislature as a whole working with the governor?
I don't know that we really have a dog in that fight as long as there's legislative oversight and that there is a proper delegation of legislative authority. I think that's really a policy-making decision and a legislative decision. Oftentimes, the more people in the room, the better in many cases. But I think as long as there is adequate legislative oversight, that's really the biggest concern.
I appreciate that answer, Mr. Chair. One follow-up question, if I may. I think George Washington would take a position on that a little bit different in his 1796 farewell address. So I would encourage the committee, if it has time, to check out some of that. I won't belabor this and quote some of it. But real life situation from the last year, please respond to this and tell me if I'm wrong. But my recollection is that the governor shut us down across the state, including in many parts of rural Kansas where I serve. And then the Legislative Coordinating Council, depending on how you want to phrase it or view the world, but either would not bring us back or decline to bring us back over many of our pleas when many of the legislators across the state of Kansas wanted us to bring us back. So I'm curious if that would change your perspective to your last answer as to whether we should spread the power out more so that our rural parts of the state and commerce across the state of Kansas is better heard versus, and in no disrespect by any means to just a handful, but the concern being, as George Washington talked about, the amount of power in the fewer amount of hands, fewer voices get heard. So if you would like to respond to that, I don't intend to put you on the spot though.
No, I appreciate that. Ryan Kriegshauser again. I appreciate the question, and I think this really is a policy discussion. As you know, the Senate version of the chemo reform bill has this joint committee that's created that really tries to spread out, as you say, the power among a few more voices than the LCC. I think the consideration that this body has to make, and I don't know that the chamber would weigh in one way or another, is what is the most efficient way. I think some of the testimony this morning on the Senate version is perhaps, the AG review and then getting the joint committee together may take too long. And in an emergent situation, you need to act quickly, decisively. And so getting more people together to act obviously takes longer. And so that's a balancing test that the policymakers here need to need to make. And maybe you have a situation where the governor issues orders and you have that, the orders are issued and in effect, and then they can be reviewed. And then whatever body the legislature decides is there for legislative oversight can have time to come together. And if they decide that that order should be removed and nullified, then they can do that. And it only stays in place for as long as it takes for that body to get together. So, I mean, really, this is a policy discussion that, of course, we would defer to this body and the Senate committee on the best way to handle, because it's your legislative authority, and how you want to delegate that and how you want to oversee that is a question for the legislature.
Ryan, I appreciate your information. Mr. Chair, at the appropriate time, back during the special session and afterwards, the reviser, Natalie, did an outstanding job of helping me prepare some material patterned after the Wisconsin Constitution and statutes. It's super easy. It's pretty quick to get the appropriate committees or the legislature as a whole together. It makes it clear in their constitution that it is constitutional and it's permissible, but now's not the right time for that. But I just wanted to share that at this time. So thank you, Ryan, and thank you, Mr. Chair.
Any further questions, committee? Representatives Schreiber, then Jennings.
Thank you, Mr. Chairman. Thank you, Mr. Kriegshauser. I was curious, I think you were referring to 48.933, is that right?
Yeah.
For the damages. There's a statement in there, basically, if the use or destruction was ordered by the governor, adjutant general, and official of a county, city, or interjurisdictional disaster agency. In 2416, I think we give authority to the LCC to approve executive orders. Would that be something that you would then add to that, to 48.933, is to include the Legislative Coordinating Council as far as if they are the approval organization, that they would also be responsible for that compensation?
I think that's an interesting question. I don't know that that would necessarily be required, but I think one of the things I list in my testimony is who does the compensation come from? And there's this idea, whoever issues the order should provide the compensation. I mean, that seems logical in many ways, that if the governor issues an order using someone's business, the state would be liable to pay that compensation. Likewise, if a county did it, the county should be on the hook to pay that compensation. But I don't know in 933 if you have to include the legislative coordinating council to get the state on the hook, if that makes sense. Because if the governor issues the order, the fact that they signed off on it, I mean, the governor still issued the order, and either way, it's the state. Does that make sense? It
would, except I think we state in there, she can't issue, the governor cannot issue the order without the approval of the LCC. Mm-hmm. So in fact, the LCC is the one that's approving the order. Mm-hmm. Yeah, you could include that language in there to make it clear, but ultimately it is her order, and so it could be argued that she is still issuing it and they are either approving it, amending it. But your point is that ultimately, since they have that final authority, it could be issued from them. And so to make it clear, that language could very well be included. Thank you, Mr. Chairman.
Representative Jennings.
Thanks, Mr. Chairman. It might be interesting to note that the transcript of George Washington's farewell address of 1796 is now trending. So thank you, Representative Samsel. So just in the context of this discussion, just in a larger, I mean, really larger way, does your client think that it's more important to get something done quickly or to do it well?
Yeah, I think it's a balance. Obviously, in any emergency situation, you have to act quickly to some extent, but getting it done correctly is very important too. Most of my experience in this type of situation is I was deployed to Afghanistan, and this same question would come up all the time: is you have to act. You might not have perfect information, but you have to do something to prevent or stop a situation or cause something to occur that you only have a small opportunity to take advantage of. And so really it's a balance, and you can't go too far one way or the other. And I think that's what's so difficult about this legislation, is finding that balance. because you can't have it so lumbering that it takes too long. But at the same time, your point's well taken, that too few voices may allow actions that are too quick and not thought out enough. And, to some extent, perhaps that's the feeling with some of these shutdown orders, is maybe they went too far and then not enough voices, or too long, rather. I think it makes sense that you take a quick pause, see what you're dealing with, and then, put things in place to mitigate any risk based on the information you have. But perhaps your point is well taken, that too few people were involved in that conversation.
I appreciate that. So in terms of the legislative process in addressing this, while it's not brand new news, it is a bill that was introduced a day or two ago that thankfully the chairman has gotten us briefed on, and we now begin to have testimony, and we have this deadline looming of, oh my God, the sky is falling, which we created ourselves. What would your sense be of assuring that the product of the legislative effort involves the greatest number of people possible in the most thoughtful process possible, so that the work product of this place is one that can withstand the test of time? We now know, by virtue of occurrences in the last year, that the work done in the 1970s didn't pan out exactly as maybe they thought it would, because they hadn't contemplated the potentials. And beyond pandemics, there are other potentials new to this state since the 1970s, and I would give you Wolf Creek Nuclear Power Plant and NBAF in Manhattan as examples of new conditions that exist that change, perhaps, the context of what a disaster might look like. Do you think it would be bad? I mean, just bad at this point. We kind of turned the corner. People are getting shots in their arms. Numbers are going down. I mean, we do see the end of this, I think, coming. Would it be terrible to just take a bit more time and have a few more people engaged and really try to develop a really well-targeted, well-defined legislative package that we maybe don't have to come back and revisit next year because we've done something that turns out was really stupid?
Right. And Ryan Kriegshauser again. No, I think those points are good, and I think that's one of the wonderful things about the legislative process is something has to start the conversation. And you have a companion Senate bill with a lot of different ideas, and those at some point through the legislative process will be melded together. And I think my constant theme when looking at KEMA, and as I've talked to folks, is due process, due process, due process. What we saw during our litigation with KEMA is that judges did not willy-nilly go around overturning orders. They were thoughtful and they were very circumspect. They understood the import of the situation. And honestly, in an emergent situation, I would say the judiciary defers to the executive just because they don't want to derail anything. And I think we saw that across the country. You didn't see a lot of TROs being granted. We had one granted here in Kansas, but that was a unique situation. But by and large, you didn't see a lot of that. And that's why I think 72-hour hearing type mechanisms whereby people can bring this to the court quickly, hopefully with counsel, and have a court opine for those really unfair situations that just, they just don't stand any scrutiny. An example I brought up is a situation, we did an open records investigation of the KEF framework, and we got all of the designations of non-essential businesses. And there was a 30,000 square foot warehouse. This business wrote into the KEF team and said, we support everything you're doing. We have moved our people off site. They're working remotely. We just need one person to facilitate the movement of product to all those remote workers. If we can do this, if we can operate in that safe fashion, we can save 100 jobs. And the KEF team said no, because they were making acoustic cleaning supplies, and they didn't deem that as essential. But I'd say now those 100 jobs are pretty essential. And so there needs to be some avenue other than a TRO, because as you know, sir, that's a high standard. When you go into court and you say, I need injunctive relief, there has to be irreparable harm. There's a lot you have to get over, whereas something like this, where it's just even the 65 129C standard, which is medically necessary and reasonable, it's the state's burden to show that the quarantine or isolation order is medically necessary and reasonable. That's quite a smaller standard than a TRO. And so that's why I think you can't go wrong with adding in due process.
Representative Carmichael.
Thank you, Mr. Chairman. My good friend and colleague from Lakin, quite frankly, has covered much more expertly than I could my specific areas of questions and concerns, but I would observe there are some common ground that we may be finding here. And as I understand what Mr. Kriegshauser is telling us, one of his highest priorities here is to preserve due process, the opportunity to be heard, the opportunity to present evidence, presumably to a tribunal, so as to adjudicate differences or disputes. Do I understand that correctly, Mr. Kriegshauser?
Yeah, I would say that's a correct characterization.
You and I absolutely agree on that point. Now, as far as the standard of proof that might be required, whether it's the same standard for a TRO or a preliminary injunction, etc., we may have to discuss. But I think conceptually, we're coming generally from the same place. But I think I also hear you saying that, and I don't want to use my words so much, but bear with me, that you would rather have a statute of specific application to the circumstance that we are in today for the duration of however we describe this pandemic than to have a statute of permanent long-term application that was poorly drafted and not well thought out. Can we generally agree on that concept?
Yes, I'd say we agree on that.
See, we're making so much good progress. Now my concern becomes, can we really draft a permanent long-term solution to what were obviously unanticipated problems in the 70s and back in the 50s? Can we really draft that type of a long-term solution based upon one day of substantive hearing and what looks like 2 conferees? And I won't ask you to answer that question because, quite frankly, it's more a rhetorical question for all of us, but I'm certainly glad to hear your thoughts on the topic if you wish.
I will gladly take your invitation to defer that answer then, sir.
Counsel, I thought I was going to give you a chance to put your foot in your mouth, but at any rate, you do a fine job, Counsel, and Mr. Chairman, I appreciate the time. Thank you.
Any other questions for Ryan? Do not see any online, none in person. Thank you, sir.
Thank you for the opportunity.
Committee, you also have written proponent testimony from the Attorney General. Is there anyone else online or in person as a proponent? Not seeing any. Next, we will move on to Will Lawrence, Governor's Chief of Staff.
Thank you, Mr. Chairman. Will Lawrence, Governor Kelly's Chief of Staff. It's good to be before the House Judiciary Committee again. I've been here a couple times, I think, between the last session and maybe the special joint committee. So I'll take a little time to touch on kind of the highlights of my testimony. It was fairly brief, and I won't touch on all of it. I think there were kind of 2 things that I would highlight. And I guess first I would start with, I think when we're looking at, Mr. Kriegshauser and I are kind of following each other today between the House and the Senate, and we've been fairly busy. And I think I'd say, and Eric Stafford made the comment on the Senate side that, one of the issues early on with the stay-at-home order, what actually wasn't coming from the statewide order. It was actually, we had it coming in different counties across the state and became kind of a patchwork, and there was no consistency in what essential meant, and so it was causing a number of issues, and that's what ultimately led to the statewide is to try to bring. We did an order to try to just put in the essential framework for the counties. The counties weren't using it, and that led to the next step. But I think the intent here has always been. in an emergency situation, you're certainly trying to do the best you can with what you got in the moment, and you do have to be able to act quickly. And, you know, while I think there are certainly portions of KEMA that need to be addressed, you know, we are still very much in the life of this emergency. And so we do have to be very careful about the changes that we're making, that they are very measured and targeted, and that, you know, we will have another chance to think about this in the context of the longer term, because we're never going to think of everything that may come up. And right now we have COVID-19 on our minds. And so we can certainly write something now that would address the immediate situation. And I think, you know, example that I would use, and I touch on in here, is the process with approving executive orders, I think here under C1 and C11 of KEMA. And, you know, the thought process of, you know, a 24-hour turnaround and going through a review and a pre-approval, a number of the executive orders issued in COVID-19 could go through that process. I think that, you know, a number of them have gone to the Attorney General's office. They've been there. They've gone back and forth. We traded comments. Sometimes they're moving quicker than others. But we have to remember there are going to be times when there can't be a lag, and you have to act very quickly. And so one of the issues we would caution against here is, while you're trying to make a decision on maybe the proper delegation of legislative authority and where it goes to, if it's Finance Council or LCC, or if it's, you know, the entire legislature, you know, that is a decision that is certainly left up to this body. But from our standpoint, you know, the governor still has the authority as the chief executive of the state to act in an emergency situation. And so the governor's office view would be that these orders should go into effect and then be reviewed. The legislature absolutely has to have a legislative oversight into that process. And we tried to build that in a variety of ways as we have gone through this year together. But it does need to be an oversight, and, you know, there's an ability to revoke, which is currently in statute, and maybe how you utilize that. But if you have to wait for a period of time to get that order in effect, that can have some consequences that we cannot think of right now. That will be a problem. And I just would very much caution that issue from the governor's office. And, you know, I'd also say, I guess a couple of points I would make is that these, in terms of notice and comment, and I guess the other point I'd make on the executive orders going into effect is Mr. Krieghauser talks about the 72-hour notice and the ability to get before a judge. You know, that really provides an opportunity for some level of cure from an individual while that's being reviewed at the state level through LCC but that way the order is in effect, so that there isn't this risk of life or property loss during that time frame. But individuals who may be aggrieved in a way that's inappropriate could have that process. But, you know, the executive orders signed by the governor, they are published in the register. So there is certainly notice provided through that process. And we certainly argue that that is contemplated by KEMA as part of using an executive order that is published. In terms of the rulemaking authority of the Adjutant General, I'm not sure that I understand the reference there. That maybe that's under his authorities as the tag, but not necessarily acting under KEMA. But under KEMA, we're not sure that we agree with that statement, but I may need to follow up offline to understand that better. But there are certainly challenges with going through a rules and regs process as well, because it does have to be a timely and sometimes very quick maneuver to handle situations. So we would certainly highlight that. And I think the other thing that I would touch on that the immediate front of our minds, and it's been touched on here a little bit, is that March 31 deadline. And I understand there's nothing in House Bill 2416 about that extension. And I know that I certainly work better under deadlines, and I know that's true for a lot of people. So we do appreciate that. But we would caution that tying the two together right now is a pretty rough proposition at the end of the day if we're having problems coming to an agreement. And the reason is, and I won't go through all this, but in my testimony, I talk about all the things that have been provided throughout the course of the pandemic, and touch on the things that will go away if that expires. And so one of the things we have a lot of back and forth on is there's this discussion about, and I think some level of confusion about an order that's done by either a local unit of government or the governor, and a declaration. The declaration it allows for the orders, although at the county level it's a little bit different, the public health side of it. But these orders come from the declaration. The declaration means a whole lot more than that. And so, you know, right now we're going through the vaccine process and receiving and distributing, and we have contract nurses that are helping actually administer it and using the National Guard. I think we have maybe 151 members of the National Guard who've been utilized through this process. And we don't want to lose all that as we get into the middle of this and as the vaccine supply is continuing to grow. So I would just say, as much as we all want the emergency to be over and for us to no longer be dealing with COVID-19, we can see the light at the end of the tunnel. But I checked last night, and to the best of our knowledge, all 50 states still do have a declaration in place. And you know, they may be at different stages of their deadline, but it's something that needs to continue, and I think it's going to need to continue for a while, probably past session. And so, you know, I guess to the extent that I can certainly make that request of a joint resolution, that should be contemplated as part of this, to also see if we can provide more time if necessary, because we may run out of time, and that absolutely does have to continue. So I think those are kind of my prepared comments. I do know there, you know, there's a lot of focus on C1 and C11. I did ask our legal counsel if he could give me a rough estimate of how many of our orders would have touched on that, and his eyes got pretty large when I asked that question, because he was had to think about that. And the reality is that probably nearly all of them touch one or both. In some fashion, either because of a belt and suspenders approach where you cite multiple, and that you might cite C11 and as well as C1. But C1 deals with a lot. If you think about just a couple of weeks ago with the weather situation, and we were getting requests for the governor to suspend the motor carrier regulation for propane drivers for their hours of service, and we were getting a lot of calls on that front. Well, that'd be a C1 executive order. Now there's some nuances there, because that may come from also a federal regional declaration, and so you're suspending both the federal for the state that are in the state of Kansas as well as any state ones. So that may or may not be a C1 depending on the posture that it comes in as. But that was again a situation where we had to move very quickly, and I was getting calls from other people that were needing that for their part of the state. And so, there are so many things that happen that I also don't think the legislature wants us to review motor carrier regulations, executive orders every time they come through. They don't come through that often, but frankly, they've more than we'd think. Flooding, we do it for hay. We do it for wildfires, and we do it for snow, and we do it for propane. So there's a variety of things that come up, and we just have to keep all those things in mind when we're having this conversation.
Thank you, Will. Questions Committee, Representative Samsel.
Thank you, Mr. Chairman. Thank you, Will, for being here today. First and foremost, I appreciate what your office is doing. I know you guys are working incredibly hard, so at no point do I want to sound critical of any of that. We do appreciate your efforts on the behalf of Kansas. Two very quick related questions, I hope. The first one is, it's every time I hear the word emergency, I have to push back a little bit because I don't have a very big vocabulary, but when I look at the definition, there's some aspect, it's like when you go to the emergency room at a hospital, it's often in some ways unexpected or urgent. Because I don't have a big vocabulary, I look at the definition of pandemic too, which is absolutely what we've got here. So I don't mean in any way to undermine that we've got a serious problem here and that it is dangerous. And so I don't know if it's more like a critical condition or something at the hospital or whatnot, but my practical point being, I have the tension between trying to use a Kansas emergency management statute to fit what I don't know is really an emergency in many ways. That is, I guess, my first point. And so I just don't know if there's like some things like financial aid and other things, very important, obviously, from the government or somewhere else. I shouldn't have said financial aid. I guess I'm in scholarship application mode, but the financial components versus some things where there may be some need to act immediately, such as shutting things down or restricting ingress and egress. And it gets into some of the prior representatives' concerns about moving quickly on these things versus our long-term solutions. Because one of my, and I'm kind of equally critical, if you will, when I read the testimony from both the governor's office and, just of the LCC as a whole, I don't really get the vibe that there's a willingness to want to give back power. And I'm not suggesting anybody wants to keep it and use it, but I don't get much of a vibe that there's a reluctance to accepting the power, not to get into my trending topic that the good representative from Lincoln pointed out earlier, but that's really what the president talked about back in 1796, was that power that starts to go there slowly, and then that kind of vibe. So I guess, is there any way that we can separate kind of more of the emergent parts of what's going on here versus some of the things, we've known about since March of last year? And is there any, because I guess I'm not at the table, and that's probably a good thing for everybody in the drafting of these things. But I didn't know if that was any part of the conversation, and the governor's office may not be either for that matter. So that's my general thoughts, Will, if you have any comments, not to put you on the spot.
Will Lawrence, Governor's Chief of Staff. Representative Samsel, I do appreciate that, and I echo not having a very large vocabulary. I would say that the term emergency is what we have for a couple of reasons. One, that's what's contemplated under KEMA, and those are the statutes that we have to continue the operations that we are engaged in. And so, I think it's hard to contemplate this as still being an emergency because it's been going on for literally almost a year. I mean, it's been longer than a year since this has all started, but the declaration is coming up on almost a year. But, it's not been that long since we had to take, medicine that's had EAU authorization from the feds and put it under lights and sirens and take it out to a rural county, to a hospital to treat a patient with severe COVID. And so, there are still a lot of things happening that, still have that one feel of an emergency, but two, KEMA does a lot of other things that are really important in terms of allowing us to mission assign agencies as part of our ESF function, as part of the Kansas Response Plan. And that allows us to use the National Guard to distribute the vaccine. They're also, as I lay out my testimony, it's as simple as collecting tests that need to be run by KDHE and getting them back to the lab. And so there are a lot of those things that go on that I understand you wouldn't necessarily call it as an emergency, but it falls under what we have in KEMA right now, and those things have to continue. Now, can you find some way to devise those pieces into a separate, type of component? Maybe, but that is something that I would definitely say needs to have some very careful consideration. And I would suggest that, the individuals working down at KDEM who are truly our experts in this area, who are much smarter than I am when it comes to these topics, have been doing it for a very long time, be at the table for those conversations, because that probably would impact the Kansas Response Plan that would have to be amended and changed. And we also definitely do not want to do that during the middle of the response, because that's what we're relying on right now to do everything. And that's the one thing. Everyone involved in the emergency side of things, from the state on down to the local to the federal side of it, they follow these plans. So if you change it now, we got a lot of people that know what to do based on the plan, and they follow that plan. And that plan will need to be reviewed and certainly revised at the end of this, but it needs to be at the end.
Thank you, Will. Very helpful comments. It almost makes me wonder if other states, and I don't think they have, but as part of a longer term solution, would have more like a pandemic act as opposed to some of these other emergency situations. But that's longer term thinking. Appreciate your time. Thank you, Mr. Chairman.
Representative Carmichael.
Thank you, Mr. Chairman. I very much appreciate the last comment of Representative Sampsell concerning whether perhaps we ought to look at infectious disease as a separate circumstance going forward, as opposed to tornadoes, fires, floods, the classic emergencies that we sadly routinely deal with here in Kansas. That being said, Mr. Lawrence, if the state of emergency or the declaration were to expire March 31, either as a result of a failure to act on the part of the legislature to extend the deadline, or if by intent the legislature concluded the pandemic is over and there's no need for a declaration, how, if at all, would that affect the availability of federal funds and resources? And what kind of money are we talking about Kansas walking away from if the disaster should terminate on the 31st of March or some other arbitrary date?
Will Lawrence, Governor's Chief of Staff. Thank you, Representative Carmichael. I will tell you that that has certainly been a point of contention over the last year. We've had this conversation several times, and it depends on the interpretation of the individuals at the federal level making the decision. But the concern that is out there, and it's being cautioned to all states. I think there may be 30 states right now that are kind of having a similar conversation and maybe wanting to end the declaration. But of course, any declaration doesn't end the emergency or the situation. It just ends the resources to be provided for that situation. But FEMA will look under FEMA, and I think I touched on this in my testimony. It's the governor who has to make the request for the declaration at the federal level. And before that request can be made, the governor has to demonstrate certain actions at the state level, which would be the declaration. And so, the governor looks to the locals for their declarations. State will do its declaration, and that goes on to the feds. And so, ending a state declaration certainly could indicate that the state believes the incident period is over. And if that is the interpretation and view of FEMA, then that would end all of those resources from the federal government coming to Kansas, especially in terms of funding. And the National Guard right now, we're at 100% funding for our National Guard members by the feds, and we would lose all of that. So in terms of a dollar amount, I don't have the exact dollar amount with me, but it would be certainly millions of dollars that would be in jeopardy, and would certainly slim down a large amount of our operations that are going on right now.
Well, Mr. Lawrence, I suspect tens of millions of dollars would be a very conservative estimate, but we can leave that for another day. Mr. Kriehauser, in his testimony, I think generally indicated that it would be the Chamber's preference that if we can't arrive at a well-crafted law going forward, that instead perhaps we deal with the present emergency on a temporary basis, and then along the lines of what my colleague Representative Jennings says is that perhaps then we could look at more long-term solutions, perhaps a pandemic act, as Mr. Sampsell, Representative Sampsell suggests, on a long-term basis, but not do it in the midst of an emergency. Do you or the governor's office have any thoughts about whether you would prefer, I hate to use the term stopgap measure, as opposed to trying to get a permanent fix, which might be drafted based only on the testimony of a couple of conferees in the midst of a pandemic? Do you have any thoughts?
Will Lawrence, Governor's Chief of Staff, and we would agree with that approach. I made that comment on the Senate side. Their bill is so I think fairly substantially different, in having a second set of emergency that is solely dedicated to a public health disaster. And I understand maybe the intent behind that. That's a very broad change in a very short period of time, and would need to be, and I suggested that maybe is something that you look for a much shorter, more targeted approach to address the issue right now that gets us to the finish line. And then you look at, you know, a longer term postmortem where we look at everything, because there's still going to be, I mean, there's still a lot that has to go on that we're going to have to look at as part of all this. You know, I can't tell you what will or will not happen between now and when this is over and we're no longer, you know, distributing vaccines, and that's, you know, generally available to the public in all the normal ways, and all those needs have dissipated. But there will be a lot of things still to talk about, and we will learn a lot between now and then. And so I do think we have to keep that in consideration.
And finally, Mr. Chairman, with your permission, one other brief area of inquiry. Mr. Lawrence, I know that in your professional career, you've spent years as a Senate staffer. And so I'm sure even though you work for the governor today, you're aware that legislators like me like to carefully guard our prerogatives under the Kansas Constitution, our legislative prerogatives. In your testimony, though, however, I do see strong mention of Article 1, Section 3 of the Kansas Constitution, which in my view imposes duties and responsibilities on the governor separate and apart and beyond statutory duties, and in fact confers upon her certain authority. I am grateful to the governor for being willing to work with the members of the legislature in an attempt for all of us to come to an agreement that is workable. But by entering into those agreements or entering into these negotiations and discussions, does that in extreme circumstances preclude the governor from exercising Article 1, Section 3 authority, should it in fact become necessary?
Will Lawrence, Governor's Chief of Staff, and Representative Carmichael, I'm not entirely sure I'm tracking the question here, but let me give it a shot, and you can correct me if I've missed the mark here. You know, certainly I've pointed to the governor's responsibilities under the Constitution as the chief executive officer, and in all these discussions, you know, it's much like the legislature and the delegation of authority, and you know, everyone has a role to play here, and everyone is making sure that role is put in an appropriate way. So we're certainly, you know, going to make sure that where there is the blending of executive and legislative authority, that's done properly. Will very much be part of those conversations. But the governor does have a number of responsibilities as the head of the executive branch, and the governor's going to continue to be doing those things. But it certainly gets a lot more difficult if declaration goes away, and we have to try to find ways to manage the emergency without those resources.
Representative Keither. Oh, you're still talking. Sorry. Your mouth is moving, but we don't hear you. Which is
isn't that a pleasure? Isn't that a pleasure when my mouth is moving and you don't hear anything? Seriously, Mr. Lawrence, I think you did answer my question appropriately, and I think we all realize that the best road out of this is to work together to come to a consensus that both branches of government can agree upon. And I do appreciate the governor's willingness to work with us in that regard. Thank you, Mr. Chair.
Representative Keither.
My turn now?
I think he's done.
Okay. Well, good afternoon, Will. I just want to reiterate just some of the language you were talking about, and that the need for National Guard, and the, you know, in my interest, the weather that we just had, you know, National Guard always comes out and helps with that. But the bottom line is, I just joined the Chamber of Commerce of Topeka as a board of directors member, and we had our report regarding the vaccinations and what's going on with them. And with the weather getting in the middle of all of it, we went through, you know, not being able to get doses, which, you know, we had to ramp up and get back to us. But, you know, we were told the rate we were going with weather in the middle of all of this was Shawnee County wasn't going to be totally vaccinated till the end of 2021. those numbers are changing daily, but it certainly does point out that this isn't going to end before the end of our legislative session, and things will need to be in place that the governor can do. So I appreciate your work on this and her willingness to work with us. I think there have been several good suggestions, so to work together to try not to rush into decisions to be made about all of this. And I just hope we can take a good approach and work together. And I thank you for coming in this afternoon. Thank you, Mr. Chair.
Representative Jennings.
Thanks, Mr. Chairman. First, I want to recognize our member from Mulvane, because I think he had it right when we went to a January date back at the beginning of this, and maybe we should have even gone beyond a January date, simply because now what I had hoped would be pressure to bring resolution was so delayed in the process that now we have an emergency basically inside of an emergency, and it's just not a great place to be. Let me ask you this, Will. The present setup as it is, all the laws that are in place right now, holding the deadline, just saying, no, if everything stayed as it is right now, and that deadline was simply pushed out to give this legislature an opportunity to not just meet and discuss, but develop thoughtful, targeted, due process-oriented solutions that go beyond the current circumstance. You think the governor could live with that?
Will Lawrence, Governor's Chief of Staff, and to make sure I understand the question, Representative Jennings, you're talking about the version that was in House Bill 2016 that was in effect last year, and then we pushed that out another until March 31st, and just take everything that's in that and extend it to another period of time.
Yeah, that's it, essentially.
Yeah, I think that certainly is tracking with taking the one for our purposes, and you know, I remember when Major General Taffanelli was the tag, and we were having a conversation. This was back when there was some flooding going on, and we talked about the 15 days probably wasn't maybe quite long enough. At one point it used to be, but you know, maybe we should look at talking to the legislature about moving that out, and it made sense to me. But I also kind of had this thought, like, I'm not sure I want to be trying to have those conversations, and you know, and maybe just leave it where it is, you know, and then we ended up there anyways. But trying to have all these conversations and figure all this out in the middle of everything else that's going on is certainly very difficult. And I think having the appropriate time to go through all of that, and again, because we are still in the pandemic, I think taking that approach is certainly something we would welcome. I don't know if there are, you know, I will tell you there need to be some tweaks there. You know, if we're talking, depends how long we're talking about, but from my perspective and thinking back through everything there, because there are those executive orders that were extended, you know, and some of those pieces. But I think by and large, that is something we would certainly welcome right now, as opposed to making any type of major changes.
Any other questions? Representative Humphreys.
Thank you, Mr. Chairman. So I'm just a little confused about, I mean, this has been confusing, I think, for all of us for a long time, but maybe you can kind of clear it up. So it has to do with, as you've already spoken about, the need for a state declaration of emergency for us to be able to get federal things. And so, but I know there's been differing opinions about that. And so what is the absolute bottom line? I mean, who is really the authority in making that decision, how do we know what is really true with that? And I'm happy to hear your opinion. I want to know what you're thinking.
Will Lawrence, Governor's Chief of Staff, and I appreciate that question. And this was something that when we got into this very early last year and we were at the risk of losing the declaration, my initial conversations with FEMA indicated that was going to be an issue. And then there was some additional back and forth where we were told by the federal government, well, we're not going to let, things expire right now in the middle of this, but we didn't get that in writing. And so there's, at the end of the day, the federal government is going to be making that decision. There's been a change of administration. There's a change of interpretation that comes with that based on who is in some of these positions making that ultimate decision. NEMA, which is the National Emergency Management Association, I think put out a document today that highlighted this issue because, and they think they pointed to about 30 states who are contemplating these type of changes. And, they do caution against, if a declaration goes away, it very well could indicate that the incident period is over. Doesn't mean we know what FEMA is going to do. So I'm not here telling you that that part's absolutely going to go away. But we still have a lot of parts that happen under the state side of this. So you got to think about this from the state declaration and what it allows us to do at the state level with the counties. And then at a certain point, when you meet that threshold to ask for a federal presidential declaration under FEMA, under the Stafford Act, then you make that request. So there are things that come with that. And we have things coming from HHS, from CDC, from FEMA. And so, I don't know at what point some of that stuff stops and starts. NGB, the National Guard Bureau, when they talk about this, and our concern at that point was what happens to our funding for the National Guard and our using of them. And at the time, they seemed more concerned that they would ding us for not having a declaration than FEMA would. And that was last year. So there are different people making different decisions in different agencies. And so, it's hard to tell. But a number of the things that I laid out, I touched on some federal stuff in my testimony, what would go away. But there's still the CEOC and our ability to, the TAG has the ability to, has delegated authority to run the emergency on behalf of the governor under the Kansas Response Plan. He will lose that authority if the declaration goes away. So a lot of things then go away, including using the National Guard, even in of itself right there.
Okay, so I'm not really alone in feeling a bit confused about this, right? But one question I did have, I thought I heard you say it's similar, like the counties and cities have declarations and then the state and then the federal, but you're not saying if a city or a county, they don't have one, you're not going to take care of your city or county. I mean, they don't have to have one for the state to act on their behalf.
Will Lawrence, Governor's Chief of Staff. So I think there may be, last I knew, and this is maybe a little bit dated information, but there I think was one county that didn't have a declaration in place, but I think nearly all the rest of them, now that may have changed. But the answer is, we're going to do everything we can for those communities. But having that declaration is what signals that you are still in a state of emergency. And so that tells us something under normal circumstances, a little bit different right now. And I will say that I don't think cities can actually declare an emergency. I think it's just the counties, but just a little.
Yeah, that's helpful.
Yeah.
Okay. Well, I just need to press on and continue looking at this, I think. So thank you.
Further questions, committee? Seeing none, we'll just, and I appreciate you going back and looking at the orders or asking that they be looked at if they were issued between C1 through 11. If you could just glance through them at you're trying to go to sleep some night and you pull up the list and let me know. I can't think of any that were based solely on C11. I think most of them, those that I pulled up are C11 and C1. And I just can't think of any that are C11. So if you think of some, let me know, because the way this bill is written, the only ones that would require LCC approval are those issued under C11. So we're not walling off all the powers, only C11. So the need to go out and quickly respond is certainly still there. You wouldn't require the 24-hour hearing, that type of stuff. So look at that and let's continue to see if we can tweak that section. I guess that's it. The only other thing to respond to some conferees, I don't want to rush this either, except we do have that March 31st deadline, and looking at the political realities of the other chamber and even our chamber, I'm not sure we can get a disaster declaration if we don't make changes to KEMA beforehand. So that's why I think we're under a little bit of pressure to make some changes. And we already, I know only a couple of you were on that committee, but we had 6 full days last fall We had 30 stakeholders. Anybody who wanted to come in, I allowed them to come in and testify. And I've spent more time on this than any other issue since I've been here in my 7 years. So a lot of time has been put on it. Maybe not by this committee and certainly not by the people who at this point in time are making those decisions, but a lot of time and effort and opportunity for people to come in has happened. Now is probably not the ideal time to make changes, but we're under pressure we've put on ourselves. And if the need for the disaster declaration in some form is to move forward, we need to take some sort of action. Well, we'll continue to talk at the end of the meeting, but that's just me at this point. We'll move on to our next conferee, Ed Klump.
Thank you, Mr. Chairman, committee members. My name is Ed Klump. I'm here representing the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. And where I can spit that out pretty fast. What we want to talk to you about today is not what is in the bill. We want to talk to you about two things we would like to see in the bill that are very, very important to us, and at least one of them needs some immediate attention. I think we'd all agree the health emergency, what we've learned about that over the last year is it's very unique from other emergencies that we've had to handle over the years. I think you would also agree, I would hope, that KEMA has worked very well over the years on the other emergencies, but we've certainly hit some hiccups with a health emergency. And so in my testimony, I have two amendments that I would like to ask you to consider to this bill. And again, I want to stress how important these are that we fix. Prior to COVID, the penalty for disobeying an executive order under the Emergency Management Act was a Class A misdemeanor. That was very appropriate for everything else. In fact, we need it for everything else, and I'm going to explain that. And then because of the reluctance, and probably appropriately so, to arrest people for not wearing masks or not social distancing and things like that, we moved it to a civil violation. Well, the problem that was created, they didn't move it to a civil violation just for a health emergency. Every emergency orders now are a civil violation. And that presents a problem for us in many of the other emergencies. For example, most of our emergencies are weather related. They're tornadoes or they're fires or they're floods. And even civil unrest, we don't have very much of that in Kansas, thank goodness. So here's what happens and why it's important that we return to the Class A misdemeanor for the non-health emergencies. And we're fine with keeping the civil penalty for the health emergencies. In KSA 22-2402 is where the authority of police comes from to allow us to make an investigative detention of a person who we suspect of either committing a crime, having committed a crime, or about to commit a crime. Without that condition, we have no legal authority to make an investigative stop. We can make a voluntary stop, but if they run off from us or tell us go jump in a lake, the conversation's over. This is important to us because in those other emergencies, oftentimes we have public safety things going on. For example, a tornado. We can have gas leaks going on that are still live. We can have down power lines that are live. We can have buildings and structures that are in risk of falling and collapsing on people if we let them in those areas. So there's really two different types of orders we generally see that this affects, and that is curfews and where we direct that people not go into a given area of a disaster. And it's very important we have that ability to make an investigative stop when we see somebody violating those kind of orders. And so it's very important that we get those back. So down towards the bottom of page 1, you'll see the bold language. And yesterday, I swore that Representative Jennings had got into my email somehow and had read my email. You recall his conversation, it almost mirrored exactly what I'm going to tell you here. So what this proposed language does is it would amend 48-939, the penalty section, by creating the a misdemeanor back for the non-health violations. You see that in A1. And in 2, you see that it retains the civil violations for the health disaster emergencies. And so what we're asking is that you fix what unintentionally got broken in KEMA for those non-health emergencies. I will tell you that we presented this same thing to the Senate. We actually thought this fix was going to be in the Senate bill. It was not. They amended the bill this morning to add a similar provision into Senate Bill 273. We would ask you to add it to this bill because we really need to fix this quickly. We are coming up on the season we typically see, tornadoes and floods, and we need to get this fixed. The second amendment that we have is a little simpler and maybe not quite as urgent, but we need to fix it. We had issues with some of our 911 centers not being able to obtain the PPE they needed to protect themselves. And you know, they're working in a confined area with close people, co-workers. And we don't know where the breakdown was, but the reason that was given by some of the people was that dispatchers weren't included in the definition of emergency responder in 48949. And that, of course, is the definition that only applies to the Emergency Management Act. And so what we're proposing, you will see, is to amend 48949 by inserting that italicized language you'll see in the 4th line up of the indented amendment proposal, where it says 911 dispatch center personnel, and just add them to that definition so they would qualify for that kind of assistance in getting things they need to keep the dispatch center running. The health of our dispatchers is very important to us, and it's important to manning and keeping those centers running. We depend on those people immensely to get the response where we need to go, as you know. So those are 2 amendments we're asking you to add to this bill. We do think there's some urgency to get this done quickly so we restore our capability to protect people's property, to protect the safety of people that may be going into those areas. And I do want to add to that, we don't use that arrest power often, but it gives us the power to stop that person and make our inquiry. And it helps us identify people who are in that purpose with no reason and are there most likely preparing to loot the homes of people and businesses. And so usually the tool is just enough that we can talk to people, get them calmed down and say, you know, we need you to stay out of here for these reasons. And they comply and nobody's arrested. But there are cases where we need that ability to arrest, and we certainly need that ability to make that investigative stop to question why they're in the area and make sure they're legitimate to be there. And with that, I'll answer questions.
Thank you, Ed. Your second amendment, is that a standalone bill anywhere? Has anyone introduced
it? It is not. It is in 273. It was in the base bill of 273 when they introduced it. We had talked to them about that on that side, and they added that to the bill. And so it exists in that bill now.
Okay. Any questions? Representative Schreiber.
Thank you, Mr. Chairman, and thank you, Ed. In the testimony, you used the term state of public health disaster emergency. I don't know that that's a consistent term that's in the statute now. I know what you're trying to get to, but
it is not in current statute. It is not in this bill. It is in Senate Bill 273. I didn't know of any other way to frame that. Hopefully the reviser can help us frame that in some manner that would be appropriate. But I mean, clearly that's what we're talking about is a health emergency where we intended to apply the civil violation.
Yeah.
We just unintentionally applied it to everything else.
Yeah. I know. I agree with the logic of it. I just think that term might be difficult to parse down the road. And I'm thinking here, since I spent a lot of time writing and helping write the disaster plans for Wolf Creek, that could be declared. I mean, you could see that as a state of disaster emergency, state of public health disaster emergency, and I hate to, you don't want any uncertainty when you're trying to work emergencies, so some clarity there. But I understand completely where you're going. I just had seen that term, and I thought, well,
hopefully we can find some language that would make that clear what we're targeting without, you know, it being expanded out to the type of things you're saying. I mean, you can claim a lot of things would be health. The power outs, you could say, well, that's a health issue, and for some people it may be.
Right.
But clearly we're concerned about statewide health emergencies like the pandemic we're in.
Right. No, I understand that, and that's
okay.
That's
Thank
good.
you.
Thank you. Thank you, Mr. Chairman.
Any other questions for Ed? Not seeing any.
Thank you,
sir. Committee, you also have neutral written testimony from Cameron Schulte with the Heartland Institute and Mike O'Neill on behalf of the Kansas Policy Institute and the Kansas Justice Institute. We have anyone else online or in person as either a neutral or an opponent? Not see any. We'll close the hearing on 2416. Committee, if you followed along, the Senate committee has spent most of the day working on their bill. I don't know how many amendments they're up to, but quite a few, and I think they're going to probably continue working through the evening until they have that done. Rumor mill is they plan to pass that out and have it on general orders Tuesday. Not that we're in a race to compete, but the sooner they get something out, the more likely that's the one that becomes the shell that we work. We saw that early in the session when as we talked earlier, we had House Bill 2048, and we ended up using Senate Bill 14 because that was the one further along in the process. So I don't intend to have us work this bill today. I don't intend to have us work it tomorrow, and I don't intend to have you come back tomorrow anymore, as long as we can get a couple bills out before I let you out tonight. That being said, I have asked the speaker to allow us to meet on Monday morning at 9 o'clock. So we will come in 9 o'clock, begin at that point in time, hopefully working this bill. I would encourage you between now and then to continue to reach out to the stakeholders, work with the revisers on getting language. Let's see where we're at. If you want to share it with me, that might be helpful, but you certainly obviously don't have to, but it'd be nice to know as we're moving forward what things look like. As you work with Natalie on amendments, if you could give her permission to share that with research, that would be helpful for them as well as they work on sup notes, so they aren't surprised when your amendment is read in on Monday and they have to have that out ready to go on Monday afternoon or Tuesday. So that's where we're at. We'll see where we get on Monday. And again, I'll continue to work with leadership to give us as much time as we need. But again, we're on a relatively short timeline if we're going to do something before that March 31st date. Let's work a couple bills and then I'll get you out of here. 2011, Natalie.
Thank you, Mr. Chairman. House Bill 2011 removes the authority of the Secretary of State to prosecute election crimes. So it would leave the appropriate county or district attorney or the attorney general. And then it requires, if the Secretary of State does become aware of an election crime, to provide information to both the attorney general and the appropriate county and district attorney.
Any questions for Natalie as to what the bill does? Not, are there amendments? Representative Wheeler.
Thank you, Mr. Chair. Thank you, Natalie. I do have an amendment. I can briefly explain this amendment as Natalie may want to.
That would be great. Natalie, if you want to get it moving, we'll have Representative Wheeler begin explaining it.
Prior to my amendments, should it be passed, this bill provides that the Secretary of State shall no longer and will relinquish power to prosecute election crimes. And then it says that power will go to the district attorney or county attorney of the county where such act occurred, or the attorney general. And in my opinion, that gives concurrent power to prosecute and is confusing. In fact, as this bill was amended, it would say that if the attorney general filed on an election crime, then the county attorney shall not file, and vice versa. And what I am proposing is that when the when the Secretary of State comes to understand that there has been an election crime, shall notify the appropriate district attorney or county attorney who will be the primary prosecutor of election crimes. It can also go to the attorney general upon request of the appropriate district or county attorney. and the Secretary of State shall inform and cooperate with the district or county attorney in the prosecution of the crime, or if the county or district attorney requests the Attorney General, the Secretary of State shall cooperate with the Attorney General. The net effect of this is it places the responsibility for prosecuting election crimes that occur in the jurisdiction where a prosecutor is in charge, the chief law enforcement official, that person is the primary person to prosecute the crime unless that county or district attorney requests the Attorney General to come in and do it for him or her on his behalf. And with that, I will stand for questions. I don't know if it's been distributed yet.
It has. Would you like to move your amendment?
I do, Mr. Chair, I do move my amendment.
Is there a second?
Second.
Second by Representative Carmichael. Questions or discussion? Not seeing any.
I may add that I have personally spoken with the Attorney General, and he has indicated no objection to my amendment. I have also spoken with Todd Thompson of the County and District Attorneys Association, who spoke with other representatives of that organization, and they have no objection to this amendment.
Good. Any further discussion? Seeing none, Representative Wheeler, you may close.
I close.
Heard the motion, all in favor say aye. All opposed say no. Motion carries. Are there any further amendments for 2011? Not seeing any. Committee, what's the pleasure? Representative Hoheisel?
Thank you, Mr. Chair. I move we pass out HB 2011 favorably as amended.
Second. Representative Neely, discussion? Seeing none, Representative Hoheisel?
Close.
Heard the motion, all in favor say aye.
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 All opposed say no. Those wanting their affirmative votes recorded, Representative Owens, Hoheisel, Heiberger, Carmichael, Ohabisam. Anyone want their no votes recorded? Representative Burris. Let's do 2365.
Mr. Chairman, House Bill 2365 provides immunity from criminal prosecution for possession of controlled substances or drug paraphernalia if that person is seeking assistance, medical assistance, either from law enforcement or emergency medical services related to that substance use. And I can take any questions.
Any questions for Natalie? Are there any amendments? Is there a motion concerning 2365? Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out HB 2365 favorably.
Is there a second?
Second.
I think we've got several. Let me give it to Representative Ralph.
Withdraw mine.
Any discussion? Need a little more time to read it? Representative Humphreys? Okay, you're fine. We good? Okay, Representative Hoheisel, you may close.
Close.
Heard the motion, all in favor say aye. All opposed say no. Motion carries. The affirmative votes, Owens, Hoheisel, Heiberger, Ohabisam, and Carmichael. And our last one is 2389. Natalie.
Thank you, Mr. Chairman. House Bill 2389 authorizes a notice to appear for unlawful possession of marijuana, and then it defines complaint in the criminal code or the Code of Criminal Procedure to include that notice to appear. And I can take any questions.
Any questions, committee? Are there any amendments? It's the pleasure of the committee. Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out HB 2389 favorably.
Is there a second? Representative Owens, any discussion? Everybody's read it, we're good. Representative Jennings.
Just one thing, Mr. Chairman. I mean, we're carving out a special notice to appear for the commission of what remains a crime in the state of Kansas that then serves as a complaint. And I don't think we do that with theft or criminal trespassing or any other number of misdemeanor crimes. I'm not sure there's a compelling reason to just carve out this one. If we're going to do it for one, we might do it up for all. I don't have that amendment, but I don't know that this makes sense to me.
Further discussion? Representative Wheeler?
I know this may not be a popular view, but it's one in which I've worked in for many years. I see this as a movement towards the legalization of marijuana and either medical or recreational. And it seems to suggest that marijuana is a harmless little drug. And from my experience, both in criminal defense and prosecution, I do not see it in that fashion. Now, I'm talking about marijuana primarily recreationally. I think there are issues on medical marijuana that still need to be resolved. We're not close to that yet, but that may have another issue. But this I see as a step forward to say marijuana is not a problem. And being in Western Kansas and dealing with the cartels that are operating out of the state of Colorado, I don't see it that way. And I don't see marijuana that so many people seem to think is the ditchweed, but now it is so powerful that it can be deadly. So I oppose this. I oppose this bill.
You look online. I just remind the committee, if you want to pull up the testimony, that we actually, the proponents were law enforcement that were asking for this. Not that that matters. I'm just reminding you that you might want to look at the reasons they thought it. No further discussion. Let me look online one more time. Okay, Representative Hoheisel.
Thank you, Mr. Chair. I close.
For the motion, all in favor say aye.
Aye.
All opposed say no. The ayes appear to have it. The ayes do have it. Those voting affirmatively wanting their votes recorded: Owens, Hoheisel, Heiberger, O'Hobson, Carmichael. Any no votes wanting recorded? Seeing none. Thank you, committee. We've done a lot of work this year. We're not done yet, but we've certainly done our fair share. Representative Ralph.
Thank you, Mr. Chair. I would like to ask the committee. I'm part of the way ahead on bill briefs, but I just received an email just now that said I've got 11 more in queue that they want to have for next week. All I'm asking is, if there's something that you would like to carry, you might shoot me an email. I don't know that I'll assign it to you. I may have some out, but if there's something you'd like to carry, because otherwise you're probably just going to get one dropped in your box to carry that you weren't thinking of, because there's that many. Thank you, Mr. Chair.
And when there's extras, at least in corrections, Representative Jennings likes to dish them up to chairs of other committees, so he'll gladly take them all. Thank you, guys. I appreciate you working late again. We'll see you all. Well, we'll see some of you in the morning if you're still around. If not, don't forget 9 o'clock Monday. I'm hoping this room, I will let you'll get notice of it as soon as I know where we get that set up. So thank you all. See you later.